Ladies and gentlemen, we are starting in a minute after the audience is successfully entering from the waiting room. Okay, I think we have a critical mass. So good afternoon, ladies and gentlemen. Good morning in the States. And thank you for joining us for this paper launch event and panel discussion titled Countering SLAPPs in the European Union, Lessons Learned from Hungary, Poland, and Slovenia. My name is Hegedüs. I work as Senior Fellow in charge of GMF Central Europe Programming. And I'm really sorry for my voice. I do my utmost that it remains with us until the end of the panel. And I am happy to welcome today's three speakers: Paulina Milewska, the author of the today presented paper, who aside of being a GMF Rethink CE Fellow, also works as Senior Advisor at the European Center for Press and Media Freedom and as a PhD researcher at the European University Institute in Florence. In the past, Paulina spent several years also working for the largest Polish independent newspaper, Gazeta Wyborcza. And I'm also welcoming our two discussants today, Dominika Bychawska-Siniarska and Zselyke Csáky. Dominika is a prominent expert on freedom of expression and free media, who currently serves as Senior Advisor to the Prague Civil Society Center. But in the past, she has worked for the European Court of Human Rights in the advisory panel of the EU Fundamental Rights Agency. And for many years, she has led the Media Freedom Observatory program of the Helsinki Foundation for Human Rights in Poland. And last but not least, Zselyke is a Policy Leader Fellow at the European University Institute in Florence, after a decade spent by Freedom House, among others in positions like the Research Director for Europe and Eurasia and leading Freedom House's Nations in Transit program. Dominika, Zselyke, thank you for accepting our invitation and being with us today.
Thank you.
Glad to be here.
Thanks. Over the past decade, SLAPPs, the strategic lawsuits against public participation, became a standard tool in the toolkits of illiberal forces pursuing authoritarian agenda, both in the European Union and beyond. And just to provide a brief initial working definition that can be expanded further in the discussion, SLAPPs are lawsuits filed with the primary goal to exert pressure on stakeholders of independent and free media, critical civil society, and academia in order to intimidate critical voices, drain their resources, and increase the material and psychological cost of critical journalism and critical thinking. While SLAPPs are present practically in all member states of the European Union, and obviously that was the key trigger behind the European Commission's anti-SLAPP legislation, there appears to be a fundamental difference between member states as well. While in Western Europe, plaintiffs are dominantly large corporations and private actors protecting their business interest with the help of this wrongful legal tool, in Central European countries with strong illiberal and authoritarian dynamics like Hungary, Poland, Slovenia under the last government of Janez Jansa, or Slovakia under the years of former Prime Minister Robert Fico, in that cases, primarily politicians, media outlets, and companies affiliated with the incumbent party exploit, or in the past exploited, SLAPPs for dominantly political purposes. So hence, in this illiberal political context, the challenge posed by SLAPPs to the freedom of media and civil society is obviously much more significant. So what are the experiences with the politically motivated deployment of SLAPPs in Central Europe? What can we expect from the upcoming EU legislation in addressing them? And what lessons learned are offered by other existing anti-SLAPP legal regimes like the ones in Australia, Canada, or the United States? Our discussions will mainly revolve around these questions. And just very briefly on the housekeeping rules, Paulina will present her paper's main findings in 15 to 20 minutes, followed by the comments of Zselyke and Dominika in 10-15 minutes each. And approximately after 45 minutes, we will go into the Q&A. And I would like to encourage you, ladies and gentlemen, to use either the Q&A function of Zoom or the chat function to submit your questions and comments to our panelists. And I also would like to remind you that the event is recorded and will be available online at the YouTube channel of the German Marshall Fund. And really, last but not least, I would like to mention that Paulina's paper is part of our flagship project called Rethink CEE Fellowship, which supports innovative research projects conducted by the next generation of policy analysts and civic activists from Central and Eastern Europe and Western Balkan. And after this rather long introduction, I'm happy to pass the floor to Paulina. Over to you.
Thank you very much, Daniel, for this important introduction and a few words that summarize why this paper and the work is, on SLAPPs in general is important. Thank you, everyone who found their time to participate in our panel. And last but not least, thank you, Zselyke and Dominika, for finding time to read my paper and prepare some comments. So my paper is titled Countering SLAPPs in Poland, Hungary, Slovenia, and the rest of the EU. And it has a few different parts where I'm analyzing the law and the cases from the three mentioned countries, the law in Australia, Canada, and the US, because in parts of those countries there are some anti-SLAPP laws, and so far there are the only anti-SLAPP laws, but also there are the laws which inspired the legislators who created the proposed anti-SLAPP directive. And finally, I'm analyzing the proposed directive and what it will mean if it will be first enacted and then implemented for Poland, Hungary, and Slovenia and its judges. So as Daniel already explained what SLAPPs are, I think it's important now to ask the question, how did it happen that this phenomena started to be so important, and I would say at this point quite well known in the European Union? So the first definition and the first research on SLAPPs was done in the 80s by two American scholars who observed what is happening to different activists, journalists, NGOs, which are speaking up in the public interest. And they observed that basically, even though these activists, etc., are exercising their rights enshrined in the First Amendment, they are taken to courts based with the being accused of the defamation by a different powerful individuals and companies, also politicians sometimes. So they described this, they gave it a very catchy name, which is SLAPPs. And basically since then, the discussion started in the US, different states implemented different laws, and also parts of Australia and Canada followed the suit. SLAPPs in Europe weren't discussed for a very long time, and it first happened after a journalist, a very important investigative journalist in Malta, Daphne Caruana Galizia, has been assassinated in 2017. And at the moment of her assassination, Daphne had around 50 open civil lawsuits against her based on defamation. They were initiated by different politicians, very well-off business people. And at the time of her death, because her sons created a foundation which owned all of her articles, they inherited the lawsuits against Daphne. So from one day to another, they had to not only go through the death of their mother, but also show up every day in different courts, as some of the cases were open in front of the British courts. So you can just imagine the extent of how much of your psychological and financial resources it can take in cases like that. So they not only managed to do that, but also together with different international freedom of expression and pre-media organizations, they launched an advocacy campaign for countering SLAPPs in the EU. And as we can see today, probably the campaign will end up in the success. Now I would briefly like to discuss why I chose Poland, Hungary, and Slovenia as my research countries. I think it was a bit explained by Daniel. So basically, the difference I can see while researching different SLAPPs is that in the Western countries, of course, SLAPPs are, they have a chilling effect as such, and they are detrimental to the freedom of expression, but they are not part of the government's plan on how to capture and silence the free media in general. So of course, you cannot do it just by using SLAPPs, and they are just one of the tools in Poland and Hungary, additionally with withdrawing the state advertisement, and trying to buy off media companies, etc., etc. But for sure, especially in Poland right now, as other tools to capture the media, they are one of the tools used to destroy the independent media. And now, starting with the example of Poland and the situation with SLAPPs here, the most well-known case in Poland that I described in my report is the case of Gazeta Wyborcza, which now claims to have over 90 SLAPP cases against them, initiated by basically everyone who is important in the governing coalition, many of them initiated by Zbigniew Ziobro, but also some by Jarosław Kurski, who used to be the head of the Telewizja Polska, so the Polish public broadcaster, also by Jarosław Kaczyński himself. There are also cases against Polityka, Polish biggest independent weekly political magazine, Okopres, news and investigative site, different Axel Springer, which is owner of different media outlets in Poland, also claims to have all over 100 SLAPP cases against them. And these cases in Poland are initiated based on criminal and civil defamation laws, as well as the press laws. So there are different ways and different tools in the law which are and can be used by those who want to produce the SLAPP. In Hungary, there are significantly less of SLAPP cases, and when I interviewed different Hungarian organizations, which are different Hungarian lawyers who represent SLAPP victims in their cases, journalists and media outlets, they said that what they can see is that the difference between Poland and Hungary is the fact that the politicians who are very high up, they are not issuing SLAPPs. It's mostly those who are in the middle of the hierarchy or lower in the hierarchy of Fidesz. He said that Viktor Orban, he can't imagine Viktor Orban even thinking about issuing SLAPP, because he's able to take over media with different tools than SLAPP itself. The most well-known case that I'm describing in the report is the case of Forbes Hungary, which has been slapped by the own very wealthy family who are owners of the energy drink, which is called Hell. They have connections to different politicians, and they basically wanted to be taken off from the list of the wealthiest people in Hungary, even though the list was created based on the generally available information. To do that, they used the GDPR, which was quite innovative from the perspective of how to SLAPP in Europe. And as the outcome, Forbes had to withdraw all of its December issue from all of the kiosk and newsstands all over the world. So all over Hungary. So similarly to Poland, Hungary has defamation in criminal and civil law as well. And additionally, as I described, there was this important case using the GDPR. And finally, in Slovenia, during the term of Janez Jansa, there was a very important case, and we have to remember that Slovenia is a country much smaller than Poland and smaller also in Hungary. So when you think about SLAPPs and their chilling effect, it's you have to think like about the number, but also when you are comparing it to the media market the SLAPPs are operating in. So the case that was very important and widely described was the case initiated by Rok Snežić, who was a tax expert and an official financial advisor to the Prime Minister, and he initiated 39 different defamation lawsuits, 13 each against 3 different journalists. So you can just like imagine how that, what kind of signal that sent in Slovenia, and additionally, how hard it is when you are a journalist from independent small media outlet in Slovenia and you have suddenly 13 cases against you, and each of your colleagues has 13 as well. Right now, I would move to discussing the SLAPP situation in Australia, Canada, and United States. So as I said before, the laws which were created before stand as some kind of an example how the law in the EU could look like, and some lessons can be taken from those laws. So first of all, the United States gives a very interesting example of how the things should work in the EU, and I feel like that that gave an important argument for the civil society groups who were like supporting the introduction of the anti-SLAPP law. So SLAPPs are regulated on the state level, and different states have their own anti-SLAPP law, and not all of them have them. And additionally, the laws differ with the level of the protection which is granted to the SLAPP target. Because of this situation, and because of the fact that right now all of the press is in the internet, so the plaintiff can argue that his rights were attacked all over the US. The plaintiffs are taking their cases to the different state than their domicile or where the publisher of the newspaper is based. In this situation, this means they are doing something called forum shopping, which is basically choosing the best place for them to sue, to be sure either they have a big chance of winning, even though like the major goal of SLAPPs is not winning, it's introducing fear and the chilling effect, or like the case will be the longest there, and there will be more and more trouble for the target. So using that as an argument, the civil society groups claim that, well, because we can see something like that can happen, we cannot just leave the member states of the EU to deal with SLAPPs on the country level. So I think that is quite an important finding. When it comes to Australia, which is interesting, the law there excludes corporations with some exceptions for suing for defamation. I think it's kind of interesting, and also at least support the victims of SLAPP cases, which are not that, I would say, not that popular based on my research in this part of the world, but from what I could see in Australia and the US are like a huge number of cases. And last but not least, the Canada supports the victims of SLAPPs with quite a wide range of different tools, but on the other hand, it's similar to the US because just 2 provinces of Canada have their own anti-SLAPP laws. So, as I said, the threat in the EU of SLAPPs was recognized after what happened to Daphne Caruana Galizia. And a year ago, on 27th of April 2022, the European Commission presented its the proposed directive. So the directive was very warmly welcomed by the case coalition, so the coalition against SLAPPs in Europe, and it cheered it as a very ambitious project. It proposed different legal tools. So first of all, it proposed the early dismissal of manifestly unfounded court proceedings, which is very important when it comes to SLAPPs, because victims are mainly suffering because how long the proceedings are, how much money they have to spend, etc. So early dismissal makes it less burdensome for them. On the other hand, what was problematic there is the word manifestly. So it can be discussed what is manifestly unfounded, and if it's manifestly unfounded, couldn't be rejected on the basis of abuse of rights by the local courts. But it's kind of a complicated discussion. Anyway, it's like it's good that that it's there, and early dismissal is basic when it comes to anti-SLAPP laws. Additionally, the procedural costs will be borne by the plaintiff in case that the case is dismissed as the abusive. Additionally, the plaintiff will have to compensate the damages, and also it might be necessary to pay penalties. And the draft, the proposed directive is offering the protection against third country judgments. Additionally to that, there is a set of recommendations for the member states. Among them, there are awareness raising campaigns, training for the legal professional, but also potential SLAPP victims, aggregated data. There is a need for creating aggregated data collected at national level, and the targets of SLAPPs should have the individual and and independent way of support. So there should be like some law firms which are supported in order to give the legal help, legal support pro bono for the SLAPP victims. So as we can see, it's an interesting set of different recommendations and legal tools. Nevertheless, it's important to underline that at this point, it's still not sure how the directive will look at the end. Both the Council of the EU and the European Parliament are working on their proposals and recommendations. And while the Parliament, which released its recommendations in March, supported even broader protection for the targets, the Council is trying to water down the directive. First of all, it defined the manifestly unfounded cases in the way that under this definition, the case have to really be unfounded, and never, and anyway, if it would be unfounded to this up to this level, it would be dismissed by the court anyway, so it doesn't make sense according to many experts. Additionally, it removed the provision regarding the compensation for damages, and there is no guidance for cross-border matters now. So I would say the first very important recommendation is that the upcoming directive cannot look like the one proposed by the Council, because then it will be symbolic, and of course it will be important because we will have the act in the EU, which is saying what SLAPPs are, which is of course influencing the fact that people are starting to recognize it as a problem, and not just as the problem of one defamation case about against some journalist, but it won't be such a important, and I would say well-working tool as we would like it to be. Another recommendation I would like to underline when it comes to Poland and Hungary, for sure now, because Slovenia luckily has a democratic government again, it's the question of judicial independence, because whatever kind of directive will be enacted and then maybe implemented in Poland and Hungary, we cannot count on countering SLAPPs here if there is no judicial independence and no rule of law, because the most important institution when it comes to SLAPPs and how this directive and how the law based on it will be working is the institution, our courts. Additionally, the directive is focusing on the SLAPP cases which are cross-border, which have cross-border implication. And in Poland and Hungary, the cases are very much local. The cases that I was looking at and which are connected to the problem of the authoritarian regimes trying to counter press independence, are very local, and they will be local by its nature. Additionally, from the recommendation side, when it comes to government who should be responsible for the database on SLAPPs, right now, looking at Polish and Hungarian government, we cannot be sure that those databases would be independent and truthful to what is happening, as the SLAPP cases are initiated by those in power. Additionally, what is important is the fact that SLAPP cases in Poland and Hungary can be initiated based on criminal law, which means that right now, as the directive is focused on the civil matters, it is not possible to counter those cases. So altogether, I think first of all, the restoring judicial independence and the rule of law is the most important, and then thinking about what should we do with the SLAPP cases which are not cross-border, and criminal law cases which are SLAPPs. Thank you very much, and I'm looking forward to your questions and comments.
Thank you so much, Paulina, for this great overview and all of the very insightful recommendations. I am sure that there will be a lot of questions to your points. I already have some, but nonetheless, I would like to give the floor to Zselyke practically with a couple of questions. First, how do you see SLAPP-related trends in a regional comparison? What are your takes on the SLAPP-related particularities in Hungary? And partially also a sub-question to that, what do you think, what is the explanation for these obvious differences between Poland on the one hand and Hungary on the other hand when it comes to SLAPPs? Is it really so simple that practically SLAPP is a tool for wannabe autocrats who are still fighting independent media but not controlling it? Or the reasons might be a bit more nuanced and deeper in many regards. So Zselyke, over to you.
Thank you, Daniel, and thank you to GMF for organizing this discussion, and of course a massive thanks to Paulina for writing this excellent paper, which I think is also a very timely paper, because as we know that attacks on media freedom have been a long-standing issue in the EU, and especially in the countries that we are talking about today. So in my comments, I will try to answer some of your questions, Daniel, but I will want to first reiterate just how SLAPPs are fitting into the broader European picture, then address some elements of the directive, because I think it is worth reiterating them. And then finally talk about the differences between autocratizing contexts, as you and Paulina were saying, or countries where SLAPPs are originating with political actors with power, and countries where they are primarily a tool used by business actors, because there is this massive difference between the two. So just on the European picture, SLAPPs are on the rise actually globally, not just in Europe, according to a recent UNESCO report that was released in 2022. And they are also on the rise in Europe, according to this umbrella organization called CASE that Paulina mentioned. So according to CASE, there has been, I think, a tenfold increase in SLAPP cases. Of course, it is, I think, hard to define some of the cases, so this is not the full number, but still you see a significant rise over the past decade plus. And so in that sense, the directive is a very welcome development by the EU, because this issue is particularly problematic in Poland, in Slovenia, but also in Croatia and Italy, some of the countries that we will not be talking about today. But I think it's important to know that this is not just a problem that is limited to the countries that we are talking about today. One additional thing that I would add is that cross-border cases, which are really the remit of this directive, account for about 10% of all cases, according to this NGO. So it's really a small percentage, these cases where they are not limited to the country where the plaintiff and the defendant are, but there's a cross-border element. But with that said, I think that the proposed directive would have definitely at least two good parts. One is that currently it has a preventative but also punitive arm. Preventative meaning that it would stop some of the cases from even appearing due to awareness raising, due to trainings. And then, of course, the punitive arm, which would make it costly for these actors to launch SLAPPs. And then secondly, what Paulina also mentioned is that ideally it should reduce forum shopping, So it should make it difficult for these actors to choose a country where they would lodge such actions. But the directive also has some weaknesses, and not just the watered down version of it, which is ahead in front of the council right now. One is this cross-border element that we mentioned, which already limits its scope. And in the watered down version, the definition of cross-border is missing, which you can find it in Paulina's brief as well, which means that if the directive is implemented, a harmonized implementation would be difficult in EU countries because each court would have its own idea of what is a cross-border case. And then secondly, more importantly, if the threshold is as high for dismissing cases as it is in front of the council, that would just mean that there is a risk that the directive has little added value because these countries already have their own pretrial mechanisms in place to dismiss cases. So I think the question is, given the lack of EU competence in this field, is how to incentivize member states to implement the directive and the recommendations if the directive is passed, or how to incentivize them to have their own national level of anti-SLAPP laws. Because there are certain parts in the directive which are less likely to be taken up by member states. One, I think, which is in the, I mean, these are in the recommendations, the sections on trainings, awareness raising, because as Paulina was saying, funding at the EU level should be made available for these to really have an impact. Otherwise, it is up to local civil society and local capacities to do this awareness raising. And then secondly, for the monitoring element, I think, again, in that case, there may be an argument for an EU-wide mechanism or EU-wide resources to be made available, which are similar to the European Media Freedom Act and what is being discussed right now with the Media Ownership Monitor. So having an EU-wide mechanism would mean that there's just much more awareness of this issue. But then this takes me to my third point, which is that even with all this assistance, there are countries where EU-level action is unlikely to be taken up or implemented. And I think the countries that we are talking about today, and especially Hungary and Poland, are those countries, because there is a difference between contexts where SLAPPs can be used by the ruling elite to further themselves in power, and contexts where, again, this is just a tool that is used by certain businessmen. And so in those cases, the main problem is that governments are not interested in solving these vexatious issue, if I may say so. In fact, on the contrary, I think they have a vested interest in not solving this issue. And so the most obvious case is Poland, where SLAPPs have been directly connected with the governing Law and Justice Party's interests. Interestingly, and I think as you made the point, Daniel, Hungary is not entirely the same, because SLAPPs haven't emerged as a primary tool to curb independent media. And I think the main reason is simply because by now, so the main reason behind Hungary's significant deterioration on press freedom has been this links to media capture. So the takeover of outlets by business interests allied with the government. And I think that means that by now there's no need for government allied actors to resort to SLAPPs or to resort to other laws. At the same time, as Paulina was highlighting, there have been cases of SLAPPs, and there has been this interesting case of the use of the GDPR, which again just shows that it's not just defamation, but other legislation can also be abused by failing to strike the right balance between freedom of the media and other rights. With that said, I think it's also important to mention that there is an interesting development that happened over the past month, which is that the Hungarian parliament voted to partially decriminalize defamation. And on the one hand, this is a good and positive development because Hungary, like much of Europe, has long been criticized for having criminal defamation laws on the books. This is a partial decriminalization, but it would extend to many cases, most of these cases, in fact. But perhaps one peculiar aspect of this decriminalization has been that many have argued that the government did this because it was aligned with its own interests, pointing out that pro-government media in Hungary has lost 10 times as many cases as independent outlets in front of the courts. Now, much of these are not criminal cases, but civil cases. But still, so this is an interesting case where government interests align with some positive developments. At the same time, this doesn't mean that SLAPPs cannot be an issue long term and a prominent risk in the future, especially because recently there have been renewed attacks against critical journalists, them being labeled by pro-government media as the dollar media, and implying essentially that they are traitors. And this is why I think it's an issue when EU legislation is reactive and it's just playing catch up. And there is not an element of forward thinking or forward looking. And I think this is why what Paulina recommended would be especially important to be included in the directive, which is this building up of local capacities and building up of local awareness by basically building up CSO capacities in the member states. And then just one final point, which I know we won't be talking about today, but I think it's important to highlight that besides SLAPPs, there are other EU legislation right now that would address a broader set of issues related to the media, which is the European Media Freedom Act that is pending again right now. And so that would address issues related to media ownership and issues related to transparency and issues related to media pluralism. So I think many of the problems that we see right now in Hungary are perhaps better addressed by that set of laws and not the anti-SLAPP directive. But that doesn't mean that this is not an important directive, again, because we need to think about the future as well. So let me stop there, and thank you.
Thank you so much, Jackie, for all of your excellent points. And I would be delighted if you could return to one on capacity building, potentially at the beginning of the Q&A. But before I would give the floor to Dominika, ladies and gentlemen, I would like to encourage you also to submit your questions in the Q&A or in the chat if the Q&A is not working for any reasons. Dominika, you have been working with freedom of expression and freedom of media now for more than a decade. How do the conclusions and the results of Paulina's research and Jake's recommendations resonate with your own experience in that field? And I also would like to have a particular question to you, and it is that when it comes to resilience building against SLAPP, it's surprising how few ECHR case law is practically appearing as a potential safety belt. And as someone who has worked in Strasbourg with ECHR case law, I would be really intrigued to learn about your opinion in that regard, whether the European Court of Human Rights can play any significant role in that regard. Over to you.
Thank you very much. Thank you for organizing this conference and for inviting me. And it's really a difficult task to talk after Paulina and her really comprehensive and up-to-date report and Zselyke fantastic comments. I would like to comment maybe very briefly on the legal environment in Poland, and then a little bit of history, and then pass to your question about recommendations. And I will try to respond to your question, Daniel, as well. So as far as the legal environment is concerned, we are really particular in Poland because we have a lot of criminal responsibility. It's not only criminal defamation, but it's also blasphemy laws, defaming symbols, which has been used and abused in the recent years against particularly activists. In order to chill them and silence them whenever they were becoming too critical. But it's also the reference to minor offenses, such as, for instance, defamation of monuments, which has been used. So there is a lot of criminal tools that can be used. And as mentioned by all of you, it's particularly in Poland, the government, the politicized states, its agencies and the organization cooperating with it, which are using those laws in order to silence activists or journalists. It's also more and more using regulatory bodies, being the Broadcasting Council or the competition authorities, in order to influence and try to chill the media in various ways. So, for instance, the Broadcasting Council has just recently imposed a fine, and they have perfect legal tools to impose fines very easily on broadcasters that will be critical, because the way they can impose and the legal basis of imposing those fines is sufficiently broad. It suffices that they are critical to the state policy or to the Christian set of values, which is a very broad notion, and a lot can be put inside. And I would say that SLAPPs occurred in the past. It's nothing really new, but we didn't define them. And I remember cases from back to 2009, 2010, when there were local journalists and activists dealing with anti-hunting, and they were protesting against hunting that had 14 civil and criminal defamation cases at once in order to silence them. The cases were opened by different self-government bodies or by the associations of hunters in Poland. We didn't name it, but it occurred because we have the tools and instruments in the law which exist and can be used in order to silence. What really helped in the case of defamation was a common campaign that was conducted, and I think it was a unique solidarity that was shown by major journalistic associations, even being polarized already at that time. And it was back in 2011, so all journalistic associations, but also major titles, local, regional, and national, that came together in order to have a campaign against defamation. And what has been seen that after this campaign in the media, there was a set of advertisement against criminal defamation. The numbers and statistics of using criminal defamation actually dropped for almost a half. So, and it became somehow unfancy for the politician to use and refer to the criminal defamation. So, because it became unfancy at the national level, the self-government stopped to use them as well. I strongly believe here in campaigns and joining forces. And as to the question, and I see Daniel is gone somewhere, but he mentioned the ECHR, and I would say that also our law provides a set of, the Polish law provides a set of remedies. So for instance, criminal defamation, whenever it is made in public interest or it targets a public figure, it can be actually dismissed, and there is no instance of defamation. But everything lies with the courts. So the courts following the European Court of Human Rights standards, and the ECHR has been a long critic of Poland and the defamation laws, and not only in Poland but most of the countries having the defamation, but also in civil cases, highlighting a number of standards that should be used by the courts. And if those standards, like differentiation between facts and value judgments, for instance, if this would be taken into consideration by the courts at an early level, probably most of the cases would not even proceed. The problem is the courts and to what extent they use the standards. And what Paulina mentioned, with the deterioration of the independence of the court, the obvious, I would say, negative perspective of all European and international instruments, and the refuse to apply them at this stage made it more difficult to litigate at the domestic level. And if we think about counteracting the SLAPPs at the national level, I would like really to refer, and Peter Nurlander has produced an excellent report, which was out in January 2023. He gives a comprehensive approach to SLAPPs. And mostly this is about providing legal aid and legal support at the early level of pre-publication review, and then at the level of courts. What happens now that most of NGOs which provide pro bono legal aid to journalists or activists, they rather work with strategic cases. So they will abandon a number of cases which actually are there. And if we want to counteract SLAPPs, we really need to provide as wider help as possible. So not only to the strategic ones, but just the other ones, because we need to mitigate the impact of SLAPPs and the fact that they are taking the resources of activists or journalists. Providing this aid and also training lawyers in order to apply and still try to argue about standards of the European Court of Human Rights. And Daniel, I think you were gone for a moment, but I just tried to explain that we have a set of standards that we can use being litigating lawyers in order to have an early dismissal of the case already now. The thing is how we can convince the court in our let's say degrading environment, and with the courts losing their independence. As I mentioned to you, the solidarity actions brought a substantial change in the past as far as criminal defamation is concerned. At least for a moment, because now the statistics are obviously rising since 2016. They are rising again. So the question is to what extent we can have solidarity actions with all different environment when we are becoming so much polarized. So it was possible in 2011 to bring all the journalistic association to the table. I am not sure if this will be possible now, at least in Poland. Probably in Hungary it would be the same. And as was mentioned earlier by both Paulina and Zselyke, although the directive is crucial and it has its weaknesses, of course, it will not be fully applying and helping in the situation of Hungary and Poland. It's not mentioning the criminal aspects, so all the criminal harassment and the criminal laws, which are the major source of SLAPPs in Poland. And also the cross-border aspect obviously is not applicable to us. And just recently, the Helsinki Foundation for Human Rights asked the Polish government whether they will be willing to apply and have a legislation against SLAPPs, taking into account the recommendation and the works on the directive. But the answer was obviously no. And obviously getting rid of all the tools that are so favorable in the hands would be really difficult at that stage. How to incentivize? I would say it's a role to civil society activists in the country to join forces and push for legal changes without really even waiting for the directive, and also just to try to use the mechanisms that are in place and try to push forward the standards in the litigation. And here, training a large number of lawyers could be a remedy, especially those working at the local level, because local activists, local journalists often are the ones who do not have sufficient funds to receive the support. And last comment, when I was talking and discussing number of times the situation with local journalists, some of them had the idea to have a PR around them, saying that if you try to open any SLAPPs against us, we have this organization which will be backing us, providing legal aid and funds for us whenever we will be targeted. And at least in some instances, just this simple message towards the local governments was sufficient not to have, at least up to today, to have SLAPPs open against those media. So this protection and solidarity be kind is really important and can be a game changer, I believe. Thank you.
Thank you so much, Dominika, for your insights, and really sorry for the technical glitches, which practically dropped me from the webinar for a couple of minutes. Ladies and gentlemen, the Q&A is open. And meanwhile, you are considering your first questions. First, I would like to give the opportunity to Paulina to react or respond to any points which were raised by Dominika or Zselyke. And I also would like to start with a question practically related to a previous one, what we received from Zoltán, and a couple of points already raised by Dominika, which is that we have in the call representatives of the broader donor community and also democracy assistance community. What would be your recommendations to that target group? Because even we at GMF, we are offering grants to support strategic litigation against SLAPPs or even capacity building. But we always struggle with the details. What would be the most effective forms of help? How should all of these programs be designed? So obviously you shouldn't do our job instead of us, but we are obviously very, very grateful for any details or insights, because obviously it's very difficult to make a proper needs assessment if a phenomenon is so new and practically barely known in different corners of the civil society community. And also the responses, what one can hear from lawyers, are from time to time very contradictory. From investing in strategic litigation support is essential to investing in strategic litigation support is practically superficial, because there is sufficient pro bono legal help available in these societies. So obviously, I think we will need time and more research and more input to get clarity on that regard. But if you could help with your contribution, at least I think that would be very, very appreciated, both from GMF and other members of the donor community. But having said that, over to you, Paulina.
So thank you very much, Zselyke and Dominika, for your insightful comments. I basically agree with all that you said. And going back to Daniel's question, based on my work in Gazeta Wyborcza, but also on my cooperation with different journalists, media outlets, freelancers in Europe, based on my experience from ECPMF, I can see that there are different types of support when it comes to SLAPPs, which is needed for different, let's say, groups of media and journalists. So first of all, when it comes to bigger titles, which are established and national, like operating on the national level. Usually they have their in-house lawyers, but that doesn't mean that SLAPPs are not very burdensome for them and very problematic. So when it comes to this kind of media, the best kind of support is usually the financial support. So basically they can either find an additional lawyer for their team when it comes to SLAPPs, or cover some of additional expenses created by SLAPPs, etc., etc. And that's something that we could see with Gazeta Wyborcza and Polityka. There are local media, and then usually they don't have their own in-house lawyer, and also using the lawyer from this town, this region might be problematic when it comes to SLAPP, which is issued by a powerful person in this place. So in these cases, like either financial support, but also suggesting them what kind of lawyers specialize in those kind of cases, or finding an organization that would take their cases, etc. I would say it's the best approach. And then we have the question of the freelancers, which is the most complicated one, I would say. And in cases where, for example, big media that printed their article are not supporting them with their lawyers, we have a problem which has two levels. First of all is the legal support that should be granted to them, so either money or like an organization who will represent that. But additionally, if it's not just one case, it's also the question of their employment, because they are freelancer, they are earning their money based on the number of articles they are writing. So the time that is taken from them by courts, by the cases, it's basically the time during which they are not working. So to support them fully, it's not only to support them with the legal aid. And also, what is an important question, and at ECPMF we have a program of a psychological support as well, so we can support financially for victims of different like violations against press to get some psychological support. We can see that like for people who have many SLAPP cases against them, and it's starting to be very burdensome psychologically, it's not only about supporting legally, but also trying to support them with the psychological kind of help, if they wish so. So I would stop here, and I would say that are the trends that I can spot.
Thank you so much, Paulina. Dominika, Zselyke, who would like to chime in with recommendations for the donor community?
I mean, if I can just add one thing, I think, which isn't probably not something new, but I think it would be important to highlight this cross-border element when it comes to donor support as well, because learning from each other during these trainings can be extremely helpful. And today we are talking about EU countries only. But as I mentioned, SLAPPs are a big problem in Croatia as an EU country, but also in other Balkans countries. So having support programs where all of these countries are included and not just focusing on the EU, I think would be very beneficial.
Thank you so much. Dominika?
Adding to what has been said, I would say that, and following on the Zselyke idea, is not only learning from each other on a cross-border aspect, but also learning from each other in the countries, because lawyers, in-house lawyers, for instance, for Gazeta Wyborcza, they have huge knowledge, and they have 6 years or more of experience now dealing with those cases, and they can be really useful to train lawyers that are based in the regions and could actually provide support to the activists and to the journalists acting at the local level. So this knowledge sharing should also occur in the countries. I would say supporting strategic litigation is, of course, important. But in order to mitigate the abundance of SLAPPs, I believe we need to invest in cases which are not particularly strategic. And we have already a number of standards from strategic cases that can be used in front of the courts and can be used by lawyers. So now the main challenge is to train those lawyers to use these ideas and then try to convince the courts to apply those rules in the given proceedings. And as we have a number of standards working on the implementation of judgment of the European Court of Human Rights also seems important. So there is a number of old judgments relating to criminal defamation in Poland or civil defamation, which are waiting for implementation, and working with them is also important to advance the standards and making them applicable in SLAPP cases.
If I could just add one more recommendation, which I forgot to underline, but I think it's important. In the situation when the directive will be enacted, I think it's very important also for donors to support the advocacy, which will be focused on the implementation of the directive, because what is underlined by the different civil society organizations, what happened with the whistleblower directive was basically that the success was celebrated too early. So we had the directive enacted, but then we could see that on the level of the implementation, basically a lot of member states started to be very slow and not exactly how we would like it to be.
Thank you so much, Paulina. Meanwhile, we are waiting for further questions. Please allow me just to jump in with two further ones. And one is practically a dimension of the question what we haven't touched upon today. And this is in some respect the role of the market and the role of the insurance market and the legal insurers in this field. As far as I know, larger media outlets, for example, have existing insurance contracts for defamation charges. And whether you have any time met this question be discussed in that circle. So how far could, for example, insurance products offer a kind of protection or safety belt for media organizations? So practically, whether there is an opportunity if regulation fails, and I just would like to go back to the point made by Zselyke that if 10% of all SLAPP cases are practically or have a cross-border nature, then anyhow we are speaking about an EU legal norm which has an application in 10% of all of the SLAPP cases. So when regulation fails, whether market can prevail. And the second question is potentially a bit less naive. That my take was that you identified lawyers, attorneys as the main target group of capacity building. And my question is, what about judges? Whether you see any opportunity to work with judges, what could be potentially the difficulties of such a work, especially in countries like Poland and Hungary, where we know that at least certain segments of the justice core is practically already captured politically. How could one identify the appropriate partners in that legal environments, and whether ultimately what would be the cost-benefit calculation, whether you still would stick to the recommendation to work with attorneys, lawyers, and invest in their capacity building, or potentially educating judges could have a more strategic impact with lesser resources. I don't know who would like to start. No one is not an option.
No. If I can comment on maybe of the lawyers and judges, I would say we should invest in both. And judges, of course, I would say I saw a number of programs, and I was training judges myself until 2013, I think was the last training. And then somehow we stopped. So we assumed that it's getting better and that the standards on freedom of speech are getting there. And this has been stopped. And I believe there is a number of associations that could provide and help, at least in Poland, with providing such training, and which had an experience of providing these kind of trainings in the past. And of course, the challenge is to what extent an EU judge, so a judge placed by the current, let's say, regime, will be eager to apply the standards. But if in a proceeding there will be the lawyer claiming and relying on the standards, combined with an NGO intervening as a third party, it would be much more difficult to the court to dismiss those arguments, and he will have a tougher job to do it. And of course, being realistic, I believe that what we will be doing is having more and more international litigation. And this is what happened in the countries where the judiciary situation and independence were deteriorating. Most of the cases were reaching further international bodies. And even I think we should focus more on UN bodies. We were working with the CHR, and UN is an avenue we need to be using more.
Thank you so much, Dominika. Zselyke, Paulina?
So I was thinking about the question you raised about the insurances covering different media outlets, and I know that it's a standard in Germany, but maybe I'm wrong, but at least for the individual journalists, freelancers, and smaller outlets, I'm not sure if it's like very popular, but I might be wrong. It's just like something that was never mentioned by anyone during the research and the interviews I did in Poland, but maybe Dominika has more knowledge about that.
No, I would say the same as Paulina. It's not something that is being raised and or used, I believe, especially where it comes to freelancers or the local ones, smaller ones. You know, the remedy they would try to keep in mind.
Thank you so much. I think that's a very, very interesting feedback, and I am just puzzled whether the difference can be explained by the different historical trajectories and traditions of these media markets, or practically these insurance products don't exist in these countries, because I think then obviously it's practically a gap which could be somehow covered by future policy measures. But I wouldn't like to hammer, obviously, on that point. So thank you for your insights. Zselyke?
I mean, I would just, I agree with what Dominika and Paulina said. And also just going back to the question of targeting judges, I agree that it would be helpful, but in a context like Hungary, I think it would be just very difficult to implement, because holding those trainings, it would be just hard to organize trainings that are held by organizations that can be then targeted. At the same time, I think that if the directive is enacted, in and of itself, that can be something that serves as a guiding principle for judges, which is what essentially Paulina was saying, that even if there are all of these problems in the current version of the directive, the watered down version of it, the fact that it exists means that for judges, they know that this concept of SLAPPs is a problem. So, you know, it's not a perfect solution, but it's something that can be helpful longer term. And And on your question on what happens if regulation fails, I think it's just like you can only rely on the recommendations part, in which case it's really up to civil society, as others were saying, to force governments to start implementing some parts of it. So that bottom-up approach is your only solution.
Thank you so much, Zselyke. As we are approaching the end of our time, I would like to say a big thank you for all three of you, Paulina, Zselyke, Dominika, for being with us today and sharing your insights and knowledge, I think, on this emerging and in the future increasingly important topic of media freedom and also, unfortunately, autocratization in Central and Eastern Europe. Ladies and gentlemen, Paulina's paper will be published today afternoon. So that was the reason why we were unfortunately not able to share the URL with you. But please visit GMF's website today afternoon and the paper will be already available. I very much recommend it for a long weekend read, which is slowly approaching. And also thank you all for being with us and very much looking forward to our next Rethink CE launch events practically in a month, dedicated to the topic of the future of EU enlargement. And I hope that many of you will join us again. Thank you so much and have a lovely afternoon.
Thank you very much for organizing the meeting and thank you for discussing the paper.
Thank you. Bye-bye.
Bye-bye.
Thank you. Bye.